So when I put my hand up this session all those months ago, when the soiree is just starting off, I rather thought we're back to normal by now, and I might dodge this bullet. But it seems that I think this new world is going to go on for some time. So I just thought this evening I'd give us a fairly high level, perhaps quite light look at the world of patents, and I think I got 20-25 minutes to do so. So as was said, I've been involved in the world of patents for many years. Just on the screen here to give a flavour of all the different types of products I've litigated over the years, just to give you an idea that patents come in all different forms and guises, all different sorts of products, from kids' toys to tidal turbine equipment to internet betting systems, etc. So many different areas of technology are ripe for patent protection. Whether it is right to protect them by patents or not, I'll come on to talk about a little later on. But first a little history lesson. So the origin of the patent system. There's some evidence that it started in ancient Greece, but nothing conclusive about that. The first recorded instance we have of a patent was in 1421 in Florence, when the city-state of Florence granted to Filippo Brunicelli, if I pronounced that correctly, a patent for a new form of transport on the Arno River. At the time, they were building the cathedral there in Florence and were struggling to ship large slabs of marble up the river on the building work. So Filippo came up with a new idea for that and was given then exclusive rights over all new means of transport on the river for a 3-year period. And we see here already one of the fundamental aspects of patent protection coming in. It's only going to have exclusivity over new things. Any patent is not going to stop someone doing what they were already doing. So anybody who was operating their prior ships on the river were not going to be affected by it. Just staying with Italy for the moment, and in 1474 there was a Venetian statute which actually introduced there a more formalised system of patent protection for new and inventive devices in return for disclosure. And that sits really at the fundamental heart of the patent system. It has to be for something new and inventive. But part of the bargain one strikes with the state is you have to disclose your idea so others may then benefit from it. And the idea behind the Venetian statute at the time was to kickstart the economy there, which was struggling a bit. And that again is a facet of the patent system. It is to try and help innovation and help technical economies to grow. So actually before the 1474 Venetian statute, in this country, just a few years prior to that, we had actually the first patent, which was a grant by Henry IV to John of Utinam for a 20-year monopoly for a process of making glass. And some of that glass actually ended up in the college chapel at Eton College. It was a very different world then. It was all John of Utinam actually did was travel back from the Netherlands, his home country, where they were making the glass this way, but imported the idea into the UK for the first time and got an English patent for that. And that idea, the idea that you could travel overseas on your holidays and bring back new ideas to Britain and get a patent from it, continued for another 500 odd years until 1977, when finally we took a more sort of global look at these things. During the reign of Elizabeth I, there were approximately 50 patents granted for various things like soap and leather and glass again. And it carried on with James I, but I think it's fair to say it rather fell into disrepute at that point, where James I was just basically granting patent rights to his buddies or anybody who contribute to his coffers. And so effectively you could buy an exclusivity or monopoly by favour from the Crown. And that was declared in 1608 contrary to our laws. As a principle, monopolies were contrary to our laws, but there was an exception for projects of new invention, still recognising the benefit of actually giving some kind of exclusivity for new inventions. And that was recorded in the Statute of Monopolies in 1624, which said that all monopolies are illegal, save for those which are less than 14 years old and to genuine true inventors. Thereafter, for 200 years, well into and covering the Industrial Revolution period, there's no actual legislation in relation to patent rights. But through the judges and the courts, the system was evolved. And the first key evolvement was required to provide a written description, what we now call specification, of the invention, again part of the process of promulgating the knowledge of the invention, that is the patent that has been made. So the first one of those patents to require a written specification was in 1718 for a machine gun. And then in 1785, just by way of example of the importance of getting the specification right, Arkwright's spinning machine patents, which had been in force for 10 years, were declared void because he hadn't provided an adequate specification. He hadn't provided sufficient information to the world at large as to how to make and use this invention. So he at that point lost his patents. And again, it's still very much true today. If you don't properly disclose your invention in the patent specification, your patent is liable to be declared invalid. You can't just say, I've invented a time machine without giving people instructions how to go and build a time machine. And then picking up from the middle of the 19th century, there were quite a sort of rapid series of developments. First of all, in 1852, there was the establishment of the Patent Office, because up until that point, in order to get a patent, you had to visit 7 offices, get the King's signature twice, and there were fees at each stage, and the United Kingdom wasn't a joined up community at that time for patent rights. So it was a long and torturous process. So the Patent Office was established, as I say, in 1852 to bring some cohesion to the patent system. And then 30 years later, the first patent examiners were appointed by the Patent Office, tasked with just checking the patent applications that were submitted, just to make sure that a proper description was being given of the investigation. And in 1902, the next development took place where, as well as checking that the specification had been properly written, the patent examiners also made some investigation to check what we call the novelty of the patent, i.e. is it a new idea, genuinely a new idea, because if not, you're not going to get a patent right for it. Interestingly, at that time, and indeed I can remember some early cases on this basis at the start of my career, there was only a 50-year, what's called a novelty period. So actually, if something had been invented more than 50 years ago, then forgotten about, and someone reinvented it, you could get a patent for the reinvention. That is no longer the case. You can dig back as far in history as you like for what we call novelty, destroying prior art, i.e. anything which covers the same invention. And just by way of example, I remember one of the cases I did. We were digging around the Second World War vessels and actually looked at the canoes the Cockleshell heroes had used and cited those as invalidating prior art for a particular design of ship's hull. So sometimes it would be well worthwhile going back quite a bit in time to see actually sometimes these ideas are not so new. The last big change was in 1977, and 2 big things happened then. First of all, as I mentioned earlier, this idea that you go overseas and bring a new idea back to the UK and get a patent for it was quashed. And secondly, introduced what were called European patents. Now, European patents are nothing to do with the EU. It's a completely separate treaty between a whole host of countries, some of which are members of the EU, some of which are not. And essentially, it provides the sort of the next development of trying to streamline the process of getting patents. So rather than having to go and get a patent in France and another one in Germany, another one in the UK, another one in Italy, etc., it gives a central clearinghouse, which if you file your patent application through that route, you could then pick up national patent rights through one application process. And as I say, all designed with streamlining the process and making it easier and cheaper for those seeking patent protection. Even back in 1977, it was recognised that if you were going to have patents granted centrally, it might be sensible to have any disputes about them resolved centrally. But that has been stuck for decades on issues about what language you sue people on. I mean, does someone in Italy want to be sued under a Spanish patent in a French court, and all those sorts of issues. And for the last 3 or 4 years, there has been something called the Unitary Patent and the Unified Patent Court hanging in the wings, ready to come into existence. All the legislation and everything has been largely signed by that. And the 3 key players in that were going to be United Kingdom, France, and Germany. But as a result of Brexit, that has all come now to a shuddering halt. And it remains to be seen whether that system will just collapse or whether it will carry on without the UK being a participant of it. So that's still a watch this space one, but one thing we do know for certain is the UK won't be part of it. So why do we have patents? I've touched upon this a little bit as I've been going through. The first one is to help promulgate knowledge. The idea, if someone discloses to the world at large their clever ideas and their inventive thoughts, other people can then build on that, and you get a sort of snowballing effect of technological development, which is deemed to be good for society as a whole. And the second reason is as a reward for innovation, and I think there's no better example of the need for this than in the pharmaceutical world. With pharmaceuticals, it can take years and cost literally millions, if not billions of dollars or pounds to investigate a pharmaceutical product, put it through all the requisite clinical testing, and then bring it to market. But oftentimes, actually, the chemical constituents can be reverse engineered very, very quickly. And if you didn't have some kind of exclusivity for that pharmaceutical product, you would have copycat products on the market within the space of weeks. No opportunity for the company that invested all that money in bringing the product to market to recoup that investment. And quite simply, the whole thing would come to a halt, and no one would make that investment in the original research and development and also the clinical trials. So, as I say, that I think is a very good exemplar of the necessary beneficial effects to society of having this system for exclusivity. But you don't get it automatically. There are a number of requirements that have to be satisfied, and I've touched upon these as we're going through, but just to capture them all together in one place. First of all, it has to be for something which is new. So you're not going to get a patent for just repeating something that someone has done already. And as I mentioned, new now is measured on a worldwide basis. So conceptually, if someone has published a PhD thesis in Uzbekistan and it's sitting on the university library shelves for anyone to go and look at, and it covers exactly the same invention as you are now seeking patent protection for, that Uzbeki PhD is going to invalidate your patent. Subject, of course, to anyone actually finding out about it. And there's always that element to any patent. Will someone find out about the key prior art which might knock it out? Secondly, it has to be something which is inventive. There has to be a sort of some real creative thought that's gone into it. And that's often, that question is often looked at in reverse and just saying, is it non-obvious? If it is an obvious development, then that's not worthy of patent protection. Also, be something which is capable of industrial application. And what we're really talking about here is just making sure things like sort of sculptures that might go in public parks or anything like that might be new and inventive, but they're not really what patent protection is about. Patents about products and processes and helping technology and engineering and the like move forward. And finally, it can't be in what's called the excluded classes, and I'll come on to talk about those in the next slide. And if you tick all those boxes and you submit your patent application, in due course you'll get a patent which gives 20 years exclusivity, for making, selling, importing products, incorporating that invention or processes using that invention. Basically, any commercial activities in relation to that invention. It doesn't stop people doing private research and the like, and developing using the invention as a springboard to the next generation. In the pharmaceutical field, because it can take many years sometimes to get marketing approval, sometimes 15, 16 years or so into the life of the patent, there are extensions possible for pharmaceuticals, but that's just a unique extension where, as I say, marketing authorization is required. So let's talk about the excluded classes. Given the sort of the time, I don't want to go through all the different excluded classes, but the one I just wanted to focus on is the one there, program for a computer. And it's set out in those words in our Patents Act, and anyone reading that might rightly assume you cannot get patent for an invention that is implemented in software. Well, that's not quite the whole story, because it goes on to say that then there only to the extent that the patent relates to that thing as such. And those two little words, as such, have caused a lot of litigation as to what they actually mean. As someone once said to me, those two little words, as such, has caused as much grief and litigation and disputes as those other two little words, I do. So with that in mind, what it really means is you cannot get a patent just for some software sitting on a computer disk, for example. But what you can do is get a patent for using that software. And those of you who are paying attention on my first slide will have seen a screenshot from the William Hill website for their online gambling system. And that was a case I took against William Hill many years ago now for a patentee who had essentially a computer program for ensuring a secure communication system between the punter sitting at home and the bookmaker, such that what you don't want to happen is for the punter to place a bet, but in the transmission of that bet to the bookie, the phone line to go down, and the punter then to grieve because he hasn't won his money on at 3 o'clock at Newmarket and he thought he placed a bet on. And likewise, the bookie that doesn't want to be taken advantage of, the punter phoning up saying, well, I did place a bet on the winning horse, but it hasn't gone through. So he came up with a clever software implemented system for ensuring a secure network or communication system for that. That's all implemented in software and got a proper patent for that. And we were successful in suing William Hill under that patent. So anyone ever says to you, you can't get a patent for software, it's not right. You just have to look for a technical effect that is produced by that software and then patent that technical effect. So I've talked about what patents are and what they provide. And I think it's helpful now to talk about, well, are patents the right thing to have or not? And there's no right nor wrong answer to this question. Every commercial environment is going to be different. Every technology is going to be different. And I'm certainly not going to ever stand up and say to someone, you should go down the patent route, because it's not going to be the right course for everyone. And a number of the factors that come into play there is, are you better protecting your idea by confidential information? If for example, I don't know, it's not really a patent example, but the recipe for Coca-Cola is kept as confidential information and is highly commercially valuable. And if you can protect your secret that way, so much the better. Not so easy oftentimes if you're actually putting a product on the market and people can reverse engineer it and acquire the confidential information quite quickly. That's not really going to be a valid alternative. But what you can do is play the two together. And a good example of this is another patent case I was involved in many years ago, where it's all to do with a new process of making large sheets of glass. Revolutionary process at the time, and really enabled much bigger sheets of glass being made for much lower cost. And that all had to do with floating the molten glass on a bed of molten tin, And so the basic patent was little more than that, as they're floating the glass on the bed of tin. But where a lot of the clever stuff was is in what temperature do you have the tin at, what impurities do you put in there, and what flow rates do you have, etc., which really unlocked the key of that invention. And that was all kept back as confidential information. And that quite often is a good way of actually playing the two together. Is it a fast-moving market? Because generally patents take 2, 3, 4 years to come to grant. And if you're on a fast-moving field, within that 2 or 3 year period, products could have moved on another generation or two. Arguably, it's not worth having patent rights in those circumstances. Are you a business that's in due course looking to attract investors or buyers? Part of this is a window dressing exercise, but oftentimes if you have a patent portfolio, that looks good in investors or buyers' eyes, and it helps increase the value of the business. As I say, sometimes it can be window dressing, but sometimes it can be very valuable window dressing as well. But I keep just on that investors and buyers thing, I think the key thing in my experience is not necessarily whether you have patents or not, but you have a patent policy. I think nothing puts people off more investing in a business if people just haven't thought about how they protect their intellectual property. But if you've got records of, well, we looked at this one and we thought about patenting, but we decided against it for these reasons, and you can show investors you've properly thought it through, and they might disagree with your thought process and whether you patent or not, but at least they're going to have some credibility. At least you thought about it rather than just muddled on without giving it any thought at all. Quality or quantity? Do you invest all your money in going for a really high quality patent, or do you go for quantity patents? And again, that's going to vary a lot from industry sector to industry sector, and how deep are the pockets. And I think the analogy here a little bit is a bit like a defensive lineup in rugby. Do you want really one sort of fast moving brute that can cross the field, or do you want a sort of a lineup of 7 perhaps slightly sort of smaller players who can cover more ground and put up a greater sort of fence to stop people coming through? So I do think having 2 or 3 patents, even if sort of patents 2 and 3 are arguably thinner than the primary patent, adds a great deal of value to the patent portfolio. And finally, a lot of people are put off by the cost of enforcing patent rights, and it's no secret that patent litigation is an expensive business. But I do urge people not to be put off by that, because the vast bulk of patents are very effective at keep off the grass signs and never get anywhere near a dispute. Even of those which do come close to dispute, usually they're resolved pretty quickly with some letters, or perhaps early in the course of litigation. It's very rare for actually a dispute to go all the way through to trial with all the incumbent costs that go with that. And even if you are in that unfortunate position, there are vehicles these days to help fund such patent litigation. So yes, as I say, enforcing patent rights is expensive, but don't let that tail wag the dog. If patents are the right course for the business, the fear of the cost of enforcement shouldn't form part of the decision-making process, whether to go for it or not. Finally, and I think I've got a couple of minutes, I got this right, just a couple of sort of modern challenges for the patent system. And COVID-19, as I'm sure you're all aware, has many people beavering away trying to find solutions to it. And it's impossible to imagine how any tweaks to the patent system could actually further encourage or incentivize that sort of process. But there is a fear, of course, that people may infringe patents in their rush, other people's patents in their rush to find solutions. So the solution adopted by the UK government is to provide an indemnity. So if anyone comes up with a vaccine or an antidote or something like the Barry's field ventilator product, and that risks infringing other people's patents, the UK government says it will give an indemnity against any liability arising from that. How that will play out in practice, we haven't seen. It's far too early days for that. And the second one, I think, is climate change, another big problem society is facing. And here we sort of hit the perennial issue with all patents in all technical fields. One person's reward or exclusivity is another person's barrier. And where should that be pitched in order to encourage innovation to combat climate change? And I'm actually sitting on the international committee looking at this very question. And we talked about whether, like for pharmaceuticals, you should have longer periods for patent protections if you come up with something which is to do with climate change. You should, in fact, have a shorter period, but shorten the barrier that it produces. And I think that the conclusion we're coming to is the 20-year period, which is a pretty much internationally recognised standard. It's not worth tinkering with that period, because the moment you make things more complicated, the more difficult it is for people to understand. And there's very much a sort of view of sort of, let's just keep it simple and have the same thing for climate change patents or for any other patents. What we are seeing, though, is quite a few patent offices around the world, the UK included, is having a fast track system. So if your patent application is to do with climate change, you can have your patent fast tracked to have it granted sooner. For some businesses, that's helpful. For other businesses, it's the patent application that they want to get the mark in the ground. And usually they don't mind too much actually how long it takes to actually have the patent granted.